Thank you very much, and thanks to all of you who are listening online today from around the country. This is Rob McKenna. I'm the former Attorney General of Washington State and partner at Orrick, Harrington, and Sutcliffe. Today I have my hat on as the president of the National Alliance for Jobs and Innovation, or NAJI, which is a coalition of nearly 400 companies, mostly manufacturers, that was co-founded by the National Association of Manufacturers. And we'd like to start by thanking NAM for hosting us here today in their beautiful offices. We have a very interesting program for you today with some absolutely stellar speakers. We're going to be talking today about the impacts of intellectual property theft, and in particular the theft of software, on the American economy and on manufacturing jobs in particular. And we're going to be doing that by highlighting the work of several states in combating software theft by taking actions under state law, under the jurisdiction of the state attorney general in each of these states, against companies that use unlicensed or stolen software to gain a competitive advantage over U.S. manufacturers and other companies. We're going to begin with remarks by the Attorney General of Tennessee, Bob Cooper. General Cooper will be talking about an action that he took involving an overseas manufacturer. Bob, it's great to have you here. Thank you very, very much for your time. Then we'll be hearing from Chief Deputy Tom Bates from the state of Oklahoma, filling in for Attorney General Scott Pruitt, who's unfortunately not feeling well. And Chief Deputy Bates will be talking about something that's occurring in Oklahoma now that is of great interest in this area. Then we'll be hearing from Stacy DeBlue from the Louisiana Attorney General's office. We'll be talking about a case there. We'll be hearing from Nicole Lamb-Hale with the, formerly of the United States Department of Commerce, who we'll introduce more in a minute. And then Travis LeBlanc, former Special Assistant Attorney General from California, who will be speaking about the California experience. Welcome to you, Travis. We'd like to thank the American Bar Association for helping us put together this panel, and in particular the committee chair and vice chair, Vic Domans, who happens to be a colleague of General Cooper in the Tennessee AGO, and Greg McCurdy, who's the vice chair of the committee and is with Microsoft. So with that, I'd like to turn it over to General Cooper, and then I'll just remind you of each speaker as we bring them up. General Cooper, thank you very much, and I'll turn the mic over to you.
Thank you, Rob. And let me acknowledge our moderator, Rob McKenna. Rob was Attorney General for the state of Washington for 8 years. He was a great colleague. He was president of our National Association and a real leader throughout his tenure. So it's a pleasure to work with him again on this project. Let me also thank the American Bar Association for organizing this panel and the National Association of Manufacturers for serving as our host. Now, when it comes to intellectual property, Tennessee, I think everyone would agree, is probably best known for its music. It's hard to live in Nashville, which is, of course, Music City, USA, and not understand the critical importance to the economy of our state of protecting our creative community from piracy. But, like I'm sure every other state on this panel, Tennessee's economy does not depend on music alone. Manufacturing is an important sector of our state's economy. According to 2012 data from the National Association of Manufacturers, Tennessee has over 300,000 manufacturing jobs, generating more than $14 billion in wages. Now, these jobs and wages in the manufacturing sector are put at risk by IP piracy, and as we found, particularly by low-cost competitors in emerging markets where the rule of law is weak. Again, the National Association of Manufacturers estimates that just a small reduction in piracy impacting Tennessee's manufacturing sector could save over 700 jobs in our state and many $million in wages. Now, not only are jobs lost and competitors harmed because of the unfair competitive advantage from IP pirates, this piracy also harms consumers by decreasing the quality of the products they buy. And it harms legitimate competition because piracy leads to decreased profit margins, which in turn slows down job creation, innovation, and product improvement. So given that background, I'd like to discuss a situation, as Rob said, that recently arose in Tennessee involving some Tennessee companies. We became aware of a company in Thailand called Mold-Mate Limited. It's a $282 million company in total assets that manufactures forklift tires and sells them in the U.S. They shipped 768,000 pounds of tires to a distributor in Tennessee during February 2011, or between February 2011 and January 2012. Now, there were at least 2 Tennessee manufacturers competing with Mold-Mate and employing at least 600 Tennesseans. So it was an obvious concern to us if Tennessee companies could be put at a competitive disadvantage by the conduct of an offshore competitor using pirated software. We considered taking legal action under the Tennessee Consumer Protection Law. Under our law, legitimate businesses are consumers deserving of legal protection from, quote, unfair or deceptive acts or practices affecting the conduct of any trade or commerce. And of course, filing such a filing of a foreign against a foreign company would face potential hurdles in terms of service of process, jurisdiction, issues such as that. But we learned that the Thai police had a criminal complaint from Microsoft and other companies, and that the Royal Thai Police had conducted a raid on Mold-Mate, uncovering 170 unlicensed software programs valued at almost $250,000. So given that there was already an active investigation in Thailand, we decided that the best course of action initially would be to communicate directly with Thai authorities and let them know of our interest and about the potential violation of Tennessee law. So in August of 2012, I wrote a letter to the Thai Attorney General inquiring about the status of the case. I asked whether any sanctions or penalties had been assessed by the court, and I copied the U.S. Ambassador to Thailand on the letter. Well, a few months went by, and we received no response from the Thai authorities, so I then wrote Ambassador Christy Kinney, requesting that the embassy assist my office in obtaining information about the status of the case, and again pointing to possible violations of Tennessee's consumer protection law. Subsequently, my staff and I had a conference call with the U.S. Regional Intellectual Property Attaché for Southeast Asia and the senior commercial officer of the Thai embassy. And it was clear at that point that the embassy was looking into the matter and that my letter could provide them with an appropriate opportunity to have further contact with the Thai officials about the Mold-Mate matter. Now, in June 2013, we got good news. I was informed that a settlement had been signed between Mold-Mate and the original complainants. The settlement involved injunctive relief, payment of monetary damages, along with legal and investigative fees and costs, and a provision requiring a software audit and inspection within the year. This was obviously a very positive result, and a great deal of work by many actors deserves credit for this. The entities whose software had been pirated had to file complaints. The Thai Royal Police had to investigate. My office had to express concerns and raise the possibility of legal action in the U.S. The U.S. Embassy had to weigh in and stress the importance of follow-through to the Thai authorities. And I'm sure there are other steps in diplomatic efforts that I'm leaving out. Now, I would be remiss if I did not recognize the work on this case in my office by Senior Antitrust Counsel Vic Doman, who co-chairs the State Enforcement Committee of the ABA section on antitrust law, as well as Chief Policy Deputy Larry Harrington. And both of them were invaluable in developing the office's strategy. So I guess one takeaway from our experience is that while litigation may be appropriate at times, it is possible for an AG to have an impact on international IP theft without going to court. It requires working closely with the private sector, our embassies, and where the groundwork has been laid with authorities of the foreign jurisdictions. But it can pay big dividends, not just in the matter at issue, but also in helping to change the business culture toward greater respect for intellectual property. So, thank you, and Rob, thank you for this opportunity, and I'll turn it back over to you.
General Cooper, thank you very much. Much appreciated. We're going to turn now to the Chief Deputy Attorney General for the state of Oklahoma, Tom Bates. Tom, thank you very much for being here, and our thanks to Attorney General Pruitt for his leadership on this issue and for making you available.
Thank you, General McKenna. I would like to also express my thanks to you personally and to to NAM and the ABA for providing this forum for us today. I will do my best to fill in for General Pruitt, who's ill today and sends his regrets. It's no secret that Oklahoma is a state in which the energy sector is vital to our economy. The oil and gas industry contributes about $52 billion a year to our gross state product, and 1 in 6 people in Oklahoma work in the oil and gas industry. There are many different players in that industry, from producers to companies that service drilling operations, large and small. One of those companies in particular is a company by the name of Chemray. Chemray is a company that's based in Oklahoma City, employs about 800 people, and they manufacture oil and gas valves, valves on oil and gas wells, and pressure control valves and regulators. It's a company that's been in business since 1948, and they are a company that has a great reputation in Oklahoma as an outstanding corporate citizen. We became aware of this situation through Chemray and Microsoft about a company in operating out of China by the name of NAJI. It is a group of companies that also manufactures these pressure and control valves and regulators. But they use pirated software to do that. The profit margin in this sector is very thin, and it has become clear to us in our review of this that this use of this pirated software is giving New Way an unfair advantage over our local manufacturers in Oklahoma. For instance, Chemray's valves, one in particular sells for about $100. New Way sells for about $85. That's a 15% difference, and when you're operating on that thin of a margin, that's very, very significant. So this use of of pirated software is, like I said, it's a significant issue for a company like Chemray and other Oklahoma manufacturers, and therefore it's a serious issue to the Oklahoma Attorney General. I, prior to Attorney General Pruitt's tenure, spent a good portion of my time doing prosecuting consumer fraud and antitrust cases for the Attorney General's office. So I'm pleased that General Pruitt really gets the seriousness of this issue. For-profit companies should be able to avail themselves of the protection of the law. While our mission is to protect the most vulnerable, this is an instance where the AG feels strongly that he has a duty to act on behalf of the state's economy and to protect it. So we're going to be looking at bringing action in this matter on several different fronts. We're going to be looking at asserting our traditional common law authority in this area to protect the state's economy from unfair and deceptive acts and anti-competitive actions. We'll be looking at our statutory authority under our Consumer Protection Act, similar to what Tennessee has looked at, as well as our Unfair Deceptive Acts and Practices Act and our Antitrust Act. So it'll be a multi-pronged legal argument. As in any case like this, some of those arguments are stronger than others, but we feel very good that we will be successful. I think, from General Pruitt's standpoint, part of the AG's duty really is not only to protect the economy, but to protect innovation, to protect the intellectual property rights that people have for those innovative purposes, to make sure innovation is spurred and protected so that we can maintain an economic advantage and edge. So we're excited about this case. We're excited about being able to engage in this area and look forward to doing more of that in the future.
Thanks very much, Tom. Much appreciated. Next, we'll hear from Assistant Attorney General Stacey DeBlue from the state of Louisiana with Public Protection Division. Stacey, thank you very much for making the trip to join us today.
Thank you, Rob. My name is Stacey W. I'm an Assistant Attorney General in the Louisiana Department of Justice, and I work within the Consumer Protection section. And we've recently pursued an intellectual property theft matter I'm going to talk a little bit about today. But first, I want to thank Rob and the others for having me on this panel, because I am not an administrator in our office as most of the people here are today. And I'm just one of the consumer attorneys who works on the ground doing these things. And Louisiana is a small state in terms of manpower in our office. So I'm very familiar with states and with the attorneys and what you do on a daily basis, and the number of complaints that come across the desks, the number of phone calls you get from constituents, from how do I register a multi-level marketing company to what do I do if my landlord won't repair the roof. And I know that the burden can be great on determining what you're going to take and what you're going to pursue on each day. And so I wanted to specifically mention that and share that perspective to really encourage everyone to pursue these IP theft cases. These cases can be a really big bang for your buck. IP theft and piracy is pervasive in many other countries. The piracy levels in 2012 in Indonesia were at 86%, China's at 77%, Russia and India at 63%. The U.S., in contrast, is at 19%. And so as technology has boomed, every level of manufacturing and industry has been more and more affected by technology costs. Every year, they become a greater portion of an overhead for any company. And so obviously those companies who are not paying those technology costs have a clear edge in competition. And their competitors are located within our states. They employ residents of our states, and they pay taxes in our states. And there are a lot of ways that the playing field is uneven when you look at foreign competition in terms of wage laws or pollution and EPA standards. We can't do anything about that. But the IP theft is something that we can do something about as a state. So the incentive is there in a big way for our states to react. And I'm here to say, as a consumer attorney on the ground, in the trenches every day, that these cases are surprisingly easy, comparatively speaking to some of the other things that your consumer attorneys may bring. Our first step in Louisiana was to pass a statute. We were the first state to pass this kind of statute right before Washington in 2010. That's General Cooper in Tennessee and Tom in Oklahoma discussed a lot of these cases can be brought under unfair trade practices, but we did pass a specific statute in Louisiana. That statute makes it unlawful to develop or manufacture a product or supply a service using stolen or misappropriated property, specifically including computer software that does not have the necessary copyrights. That statute is part of our body of unfair trade practice law, and it refers to all the penalties and violations of that chapter. But a really nicely crafted part of our statute states that it specifies that a violation occurs each time such product is sold or offered for sale. For anyone who has done work in the consumer protection arena and has worked with unfair trade practice statutes, you know that the per violation language of the statutes is very important, and it's always a fight, or it's up in the air about what constitutes a violation. So to have that within our statute makes it a very generous thing that we can do, and it makes it very attractive for us to bring these suits. It's all cut and dry right there that per violation is every single time one of these products is offered for sale. The other significant factor under our statute is that the product must be sold or offered for sale in competition with those doing business in our state. So that's what we needed to pursue an IP theft case. And my Attorney General, Buddy Caldwell, said, find me an impacted business. And that's exactly what happened last fall. We identified a Chinese corporation, Cambo Electrical Company, that had an established record of software theft. Among other things, this company manufactures barbecue grills, which are shipped to big box stores all over the United States. And in Louisiana, food is one of the most important things, maybe behind politics or football, given the day. So we sell a lot of grills, and that is key to us. And in order to manufacture a grill, ship it internationally, you're dealing with a lot of different software, from manufacturing, product design software, supply chain management, e-commerce, retail management software. There are many chains of software involved. And a raid had already been conducted by the Chinese officials, and it was discovered that in this company with over 3,000 employees in 13 buildings and a huge industrial complex, they had virtually no software licenses at all. So we also learned that when the software companies themselves take action against these companies who are involved in IP theft, the Chinese courts typically force a settlement, and that settlement does not require the company to get licensed. The states, on the other hand, carry a big stick, and that's injunctive relief. And these manufacturers cannot exist if they cannot ship into our country and ship into our state and sell within our boundaries. And so with our statute, the conduct they were engaged in was specifically illegal, and the state of Louisiana could have filed a suit for injunctive relief to prohibit the sales of their products within our state. So we identified a local company who also manufactured barbecue grills in direct competition with Canbo, and we sent Canbo a demand letter. We attached a draft petition for injunctive relief, as well as civil penalties, restitution, and damages, and we demanded that Canbo remedy the software violations we detailed and report back to us by January 31st. That letter was sent on December 19th. We heard back from Canbo on January 29th, just a few weeks ago, and they asserted that they had made a partial purchase of software and that they were working to become fully compliant. Even with Chinese New Year in the mix there right at the beginning of February and the delays that were related to that, we have already received their settlement signed with the Chinese, in the existing Chinese suit, wherein they promised full legalization. They will purchase all the software that had been, that they had not purchased. They have an agreement signed with the distributor within 5 days from Monday, which was when the agreement was signed. So the order should be expected soon. They have promised to delete all the pirated versions of their software, the Microsoft software, pay for past violations, pay restitution, and to accept an audit within 1 year starting from the date of the settlement agreement. So this was a huge success with very little legwork on our part, which is, again, when you have states that have limited resources and you have the individuals on the ground doing the jobs that need to be done, you can work, as General Cooper said, with the private industry to really affect change in these areas. When in our office, basically the hardest thing that we had to do was figure out how to fill out the slip to send the FedEx to China. So with the initial letter, that was literally probably the most time-consuming part of the whole process, and it has quickly come to a resolution, and we're really excited about.
Stacy, thank you very, very much. Appreciate it. Next, we'll hear from Travis LeBlanc, former Deputy Attorney General from California, where they took, yet again, a slightly different approach. And that's what we're illustrating today, is the different, overlapping yet also distinct approaches that the states have been choosing to take. Travis, welcome and thank you.
Thank you, General McKenna, and thank you especially for your invitation to participate on this panel and for your many years of nationwide leadership on intellectual property protection across the country. Thank you. I also want to thank NAM, the ABA, and my distinguished co-panelists, each of whom continues, along with California Attorney General Kamala Harris, to fight for intellectual property protections in the United States and abroad. As I know you all appreciate, in a globalized world, IP theft anywhere is a danger to competition everywhere. I am delighted to be here this afternoon to discuss California's experience with addressing intellectual property infringement as an act of unfair competition. Before beginning my remarks, I'm obliged to note that I am here today in my personal capacity, having departed the California Attorney General's office last year and recently returned back to Washington, D.C. As such, I do not speak for General Harris or for her office, but today I will offer you my insights as the former executive head overseeing California's antitrust work and the office's intellectual property work more generally. I am also delighted to report that my former colleagues Emilio Veronini, Adam Miller, and I think Kathleen Foote are participating today by phone. With them, you're in good hands. And let me particularly acknowledge Emilio, who has been central in developing our IP enforcement cases in this arena. So often when we discuss IP rights, we focus on the rights holder and the importance of ensuring their creativity and incentivizing their innovation. We talk about the investment they must make in order to innovate and the risks they take when developing new ideas. We recognize that having an IP right incentivizes an individual or an organization to create and gives them at least some expectation of a reward. In short, we know that IP rights are critical to the spirit of innovation. But let me propose to you that IP rights today are also necessary to protect and encourage a much larger group of stakeholders. Today, I want to shift our conversation to broaden our vision of IP theft and the people and businesses it can impact. I want us to consider not just the rights holder, but also everyone else who is negatively affected by piracy and other intellectual property crimes. When I am talking today about IP infringement as an act of unfair competition, I'm really talking about all the non-rights holders who are impacted by the infringement itself. Think about the company upstream of the rights holder. For example, the company that loses business when the rights holder can no longer afford its goods or services. And there are also the negative downstream effects of IP crime. Think about honest businesses downstream of the rights holder, an honest business that respects IP rights and therefore pays licensing fees in full. That downstream company faces higher input costs than does a dishonest competitor. The honest company could have to charge higher prices or invest less in research and development as a result of its higher input costs. Alternatively, the dishonest competitor, who does not pay licensing fees, can charge lower prices and invest more of its profits. Either way, the dishonest company, which does not respect IPR, has an unfair competitive business advantage over its law-abiding business competitors. But the negative downstream effects of IP crime also extend beyond private interests. The public interest is also negatively impacted. There are the governments that lose tax revenue from the impacted companies, or that have to combat other crime, like terrorism and drug trafficking, that IP infringers fund. The government may also have to cover the medical costs of anyone who uses a counterfeit product that harms them. And while consumers may enjoy lower prices initially as a result of stolen intellectual property, they may also be deceived into buying goods they believe to be wholly lawful, or they may suffer from shoddier products, or in the future, they may suffer from decreased competition and inflation as honest, law-abiding companies exit the market. In California, we have felt the breadth of the consequences that IP infringement can have, and not just on the rights holder. California is the United States' largest economy and the country's most populous state. As I know you all appreciate, intellectual property has been central to California's success and is actually at the heart of California's spirit of innovation. And as I know you all well know today, in today's world, intellectual property doesn't just matter to IP-intensive industries who produce it. IP is also critical to all of the industries that use and rely upon it. And that is basically every industry. Virtually our entire economy relies on some form of IP, either as a producer or as a consumer. In California, this is clear in the manufacturing sector, the third fastest growing industry in our state in 2012. Intellectual property is integral to manufacturing. It can improve the manufacturing processes, make them faster, more efficient, more precise. And it helps to create products that better satisfy consumers. In fact, a private consulting group estimates that nearly 70% of manufacturing jobs and 75% of total U.S. manufacturing output came from companies that create IP or often use it. Today, I am here to discuss two specific cases that the California Attorney General recently brought against foreign IP infringers. Last year, General Harris sued an Indian company, Pratibha Syntex, and a Chinese company, Ningbo Bian. Because this is ongoing litigation, I'm mindful to limit my comments about these particular cases to the allegations contained in the complaints. Suffice to say, both companies, Pratibha and Ningbo, produce clothing like shirts and pants. Both companies use unlicensed software in the operation of their businesses. This clearly violates the law of the United States, China, and India. By not paying the appropriate licensing fees and using unlicensed software, they are able to reduce their cost of doing business, effectively making designing and producing their clothing cheaper. By not paying licensing fees and using unlicensed software, these foreign companies deny California software companies like Adobe and Symantec their rightful revenue. And by artificially lowering their cost of production, the foreign companies attack California clothing companies like The Gap and American Apparel. Our office believes that these foreign companies unfairly threaten American competitiveness and put the jobs of our citizens at risk. They likely also deprive the state of tax dollars and may deceive consumers who believe the clothes they are buying are wholly lawful. As a result, this deception diverts consumers from legitimate business, and at least in these cases, it diverts them to consumers to foreign competitors. We ask the courts to prohibit the further distribution of Piracy by Ningbo products in California and to assess substantial penalties on both companies. At present, both cases are still pending. Piracy is pursuing a motion to dismiss, and we are waiting the completion of Ningbo's foreign service process. As you know from my other panelists, California is not the only state to pursue this kind of case. In California, we went after IP infringers that challenged our domestic apparel manufacturers because apparel is an industry that matters in California. The California apparel industry employs 58,000 of our citizens, and it brings in more than $5 billion in revenue each year. In other words, the Chinese and Indian infringing companies threatened our jobs and our economy. $5 billion is a lot of money. So for us, the harm to our state is significant. There is no question in my mind that protecting intellectual property and technology that depends on it is integral to the work each of us in this room does, whether we are coming from government, industry, or law firms. And with globalization, the reduced cost of reverse engineering or duplicating, and the availability of powerful technology at moderate cost, IP is an asset that is increasingly under threat. As I stated at the beginning of my comments, IP theft anywhere is a danger to competition everywhere. That threat reaches beyond the impact on the rights holder to that of other businesses, the government, and consumers. Thank you for giving me this opportunity to speak with you this afternoon. I look forward to your questions and the discussion with my fellow panelists.
Travis, thank you very much. Much appreciated. Our final speaker before we open up for Q&A is Nicole Lamb-Hale with Albright Stonebridge Group. She is the vice chair of the board of the National Alliance for Jobs and Innovation, and she is a former assistant secretary of commerce focused on manufacturing issues. Nicole, we're delighted to have your involvement in general and your participation here particularly today. Thank you.
Thank you so much, Rob. And it's so exciting to be a part of this panel and hear the good work that's going on. First, I want to thank the ABA and NAM for hosting us. And on behalf of NAJI, I'd really like to compliment the work of the representatives from the Attorneys General offices around the country on the important work that you're doing to protect what I like to call the secret sauce of advanced manufacturing, which is intellectual property. So we really appreciate that. As Rob mentioned, I formerly served as the Assistant Secretary of Commerce for Manufacturing and Services in the International Trade Administration. And in that role, in my current role as a consultant, a global strategy consultant with Albright Stonebridge Group, I work with manufacturers to help them realize their international business goals. As Rob mentioned today, I'm wearing my hat as Vice Chair of NAJI, and I'm very proud of the work that we're doing. As Rob indicated earlier, NAJI is a nonpartisan organization of concerned businesses and industry experts working together to stop unfair competition from the use of stolen intellectual property, whether it be through piracy, counterfeiting, or trade secret theft. Every year, billions of dollars worth of IP-protected information technology is stolen by firms around the world, but especially in nations with high piracy rates. This theft places the IT industry and law-abiding companies in industries like manufacturing, where IT is a critical component of R&D and production, at a competitive disadvantage. I want to share a few statistics today to amplify this issue. According to the U.S. Department of Commerce, in 2012, manufacturers spent 25% more on software and other intangible IP and IT than on new equipment, facilities, and other structures combined. A recent survey of the National Association of Manufacturers memberships reveals that 79% of all U.S. manufacturers consider software to be important to the success of their business. The U.S. economy loses $300 billion with a B annually due to IP theft. This theft not only harms job growth, economic growth, and innovation, but it also creates barriers to market entry and gives the thieves competing against U.S. manufacturers an unfair competitive advantage. According to a recently released study commissioned by NAJI and NAM, from 2002 to 2012, the U.S. manufacturing sector lost over 42,000 jobs due to the global piracy of software. This number was derived in part by estimating the magnitude of the cost or pricing advantage gained from firms engaging in software theft. And if we address global software theft, the same study shows that reducing the piracy rate by just 2.5% per year for 4 years would create 27,239 new manufacturing jobs, add $8.7 billion to U.S. GDP, and generate $29 billion in revenue to manufacturers. When you add in the jobs derived from manufacturing and other sectors of the economy, a 10% reduction in global software piracy over 4 years would add an estimated total of 65,745 jobs to the U.S. economy. Those are real jobs. Statistics like this drive the work of NAJI. The work of the attorneys general to combat IP theft by enforcing the laws on their books in their states is an important and effective deterrent to those who choose not to play by the rules. It is also an effective means to changing the culture supporting IP theft. In closing, I hope that everyone that's participating in this webinar will consider joining NAJI. Our goals are fourfold. First, to decrease unfair competition from the use of stolen IP. Second, to shift norms towards compliance and respect for the rule of law and expand access to foreign markets. 3, to increase awareness of policymakers and citizens on the critical importance of IP to the U.S. economy and the manufacturing sector. And 4, to foster both public and private measures to mitigate the harm that's caused by unfair competition resulting from IP theft. As a member, you have the opportunity to benefit from investigative resources that can help you to identify your competitors' illegal behaviors, partner with experts on research initiatives, publications and speaking engagements, collaborate with leading companies on partnerships that protect your IP and eliminate trade barriers, and to improve the rule of law by becoming a part of the conversation. So thank you so much for the opportunity to speak today, and I look forward to any questions you may have.
Nicole, thank you so much. Before we turn it back to the operator to take any questions from folks who are participating online, and operator, if you'd like to go ahead and get ready to do that, that would be terrific. I'd like to be able to take questions from folks that are here in the room with us. And while you think of what that question might be, let me just insert an unpaid advertisement for those of you who are listening and are not currently members of the ABA Antitrust and Consumer Protection section. We encourage you to sign up. We actually have sign-up materials here in the room. The gold-colored paper, and I, for one, need to do that, I will confess, so count me in. And you can also sign up online, I believe, through the ABA if you're listening online. We're taking video of today's panel, and hopefully by the end of the panel I'll be able to announce how people will be able to watch that. So we're checking on that, but we are videotaping this, and hopefully that'll be available. So are there questions from any of the listeners who are here in the room with us before I take questions from the folks online? Yes, please.
I was very interested in the discussion about...
Hang on just a second. We're going to bring you a mic so that we pick it up on the recording. Thank you.
I was interested...
Yes.
Paul Viganti, reporter from Global Competition Review. I was interested in the discussion of how Louisiana passed a statute to enable it to obtain injunctions to prevent imports, basically kind of acting almost like an ITC. I was wondering what are the options for states that don't already have similar legislation? Would they need to pass it in order to do that, or are there other powers they can exercise?
Our statute was passed in 2010, and it was sponsored by an individual legislator who was interested in this. He was, I believe, approached by and partnered potentially with some private industry to do that, and maybe a lobbying firm. But once it was passed, it became part of our Unfair Trade Practices Act. And as some of the other states here mentioned, that they can go, you could still have an action under the existing unfair trade practices statutes, the way most of them are drafted. Most states have little FTC acts, which are fairly broad and would give rise to this kind of claim, I believe, and I think most other states believe that as well. It did help us particularly just to have it specified on the books, and like I said, primarily because of the remedies clause and making that per violation so clear that it was every time a product came up for sale. these cases, while ours was fairly easy and straightforward, if we did have to go to court with it, and if we had to do a lot of this research on our own, if there had not been an existing RAID and data that we could mine in order to bring this, would be quite an undertaking. And to do that with only perhaps the promise of a $5,000 penalty under our statute would be difficult. But having that per violation language in our particular statute was very helpful, and it incentivizes a state who might want to amend their laws or have a specific law there to bring something like that would really make it more worthwhile. But the action does exist under most states' Unfair Trade Practices Act, I would imagine.
Exactly. Any other questions from folks here in the room? Yes, sir.
First, thank you. My name is Andy Popper. I'm a law professor at American and a proud member of NAJI. I was fascinated by this presentation and for the at the state enforcement level of your willingness to engage in enforcement efforts, not just beyond your borders within the United States, but outside the United States. And I wondered if you could say a little bit more on how you effectuated collaboration with foreign officials. Because obviously, whether you're in Louisiana or Tennessee or Oklahoma or California, your primary responsibilities are within your state. And when you initiate these kinds of prosecutions that are outside of the borders of the United States, you're walking in kind of delicate jurisdictional areas. And I wondered if you could just, for the benefit of the program, say a little bit more about how you collaborate with your counterparts, whether they're in India or Thailand or China, and what you might recommend for AGs in other states.
Very good. I'm going to ask General Cooper to start. Rob.
Sure. Yeah. Our interest, obviously, is that economies are no longer just the state or national, but they're international. And both in terms of Tennessee products trying to be sold worldwide, as well as competitors worldwide coming into Tennessee. So I think we have to be cognizant of the impact that events can have outside of our jurisdiction and outside of the United States. And that's true in Tennessee, not just with music intellectual property, and obviously, music made in Tennessee is played all over the world, but manufacturing. So when we learned about this, it obviously did provide, we needed to proceed cautiously. We wanted to have a cooperative relationship with the legal authorities in Thailand. And so we reached out to them in a very collaborative manner in terms of how we communicated with them, expressed our interest and expressed our interest in the matter, as well as our interest in working with them hand in hand. And likewise in reaching out to the embassy. Again, our goal was to get them involved, but to recognize what the jurisdictional lines were and to work in a collaborative manner. And I think that approach paid off. And fortunately, we did not have to get adversarial.
So, would others like to comment on that? Chief Deputy Bates?
I agree collaboration is important, and we're certainly engaging in that process. I do think it's important that when you identify these types of cases that you have to have a solid local hook. I mean, a distributor or something that is infusing that product into your state and into your stream of commerce, so that when you talk about the injunctive relief that our state statutes provide, that when you bring that case to court and you enjoin the sale of that product, that there is a distributor or a local entity that is going to be very motivated to engage upstream and to make sure that if you're not successful in having good collaboration and communication, that you can pull those levers and make sure you get that.
Travis LeBlanc.
Yes, thank you, General. I have, it's basic in American law. I think everyone would agree that a foreign company doing business within our state, whether that foreign company is domestic or international, is subject to the laws of our state. From our perspective, in reaching out to sort of internationally foreign companies, we have, and countries, I've, in the last 2 years, traveled abroad to some of those countries. I've been to Thailand. I have sat down with the Attorney General's office. I've sat down with the minister at the Ministry of Commerce to meet with exporters there about this particular issue. We didn't talk about a case that Massachusetts brought against a Thai seafood company. I sat down with the CEO of that company and talked to him explicitly about this particular issue. I've been to Mexico and sat down, with the Attorney General's Office of Mexico. They've also come to the United States and met with us about it. In each of those instances, in fact, I've been to Brazil and spoken with Brazil about, in particular, General McKenna's case against, or matter, I should say, against Embraer. And in each of those instances, it was done with the support of the United States government, whether the United States Department of State, the Department of Commerce, the embassy. In each of them, they arranged for meetings. Sometimes they brought them to us. In the case of Thailand, for example, they brought a delegation to California, and we sat down and talked about these issues there. So there's been, I think, on the policy side at least, a lot of coordination in raising awareness, in talking about lapses in the laws, in trying to, organize the private sector in the United States to support them in their initiatives there, and to possibly even, rethink the way intellectual property enforcement is done in their country. So I think it hasn't just been a complaintless file. Before we filed the complaint, we reached out to the U.S. government here, and we made sure that we weren't stepping on too many toes. And similarly, when the complaints were filed, we heard from at least one of the countries that the company that was a defendant reached out to their government for help, in the case. So it's critical that we work together not only as states, that we work together with the private sector here, consumers groups, but that we also work with our foreign counterparts to make sure that we're all aligned in where these efforts are going.
Well said. Stacy, would you like to weigh in on that, Stacy?
Sure. Our statute, of course, in this situation gives us some specific jurisdictional ties when there's competition within our state, but the bottom line is that our state has never been afraid, and our Attorney General Caldwell has never been afraid to just kind of jump right in. We'll cross that jurisdictional bridge when we come to it. That's what we did with Chinese drywall when it was introduced into our state years ago after the hurricanes, and we had major problems with homes throughout there. We've had depots in Germany now twice. We've gone to Hong Kong and London. We've successfully established spoliation by the German corporation. So I think you could be surprised by the success you can have if you're willing to take that risk and go in and do it. So when there is something in the stream of commerce within your state and that's well established, then you may have a lot of success.
Very good. And I would just comment, we did take an action, or initiate an action when I was Attorney General of Washington State that would be viewed as similar to what Tennessee did with General Cooper. We sent a letter to Embraer when we were presented with evidence of fairly large-scale unlicensed software problem at that aircraft manufacturer, and then the action was completed by my successor, Attorney General Bob Ferguson, with a follow-up letter that resulted in the company coming into full compliance. So there, in both cases, in all of these cases, I think the attorneys general believe that they can reach overseas companies in a way which is analogous to reaching out-of-state companies generally, where our laws will reach them because they choose to enter the stream of commerce in our states, and that's really the key. We expect we'll see more and more of this over time because AGs are finding surer and surer footing in their state UDAP statutes, as we call them, unfair or deceptive acts or practices, and that's a good thing to see indeed. Professor Popper, let me just say it's delightful to work with you on the NAJI board. Thank you very much for being part of that. Other questions from folks in the room? If not, let me turn it over to the operator to open up for questions from people who are listening online.
At this time, if you would like to ask a question, please press *1. Again, that's *1. We'll pause for just a moment to compile the Q&A roster. Your first question comes from Josh Cisco.
Please go ahead.
Hi, this is Josh Cisco with the Policy and Regulatory Report. I was just wondering if there is any interest from federal regulators in this issue, or if the states are so far the only ones to really address it.
Let me offer a brief answer, and then I'll ask Nicole Lamb-Hale if she'd like to comment on that, given her extensive federal experience. When I was serving as Attorney General, a group of us, including General Cooper, General Pruitt, General Caldwell, and I believe also Attorney General Harris, all signed a letter to the Federal Trade Commission that I circulated. We had, I think, almost every state in the country sign on to this letter to the FTC, asking them to exercise their authority under Section 5 of the FTC Act to pursue these kinds of cases, to treat stolen IP as an unfair and deceptive practice under the Federal Trade Act of our country. So I think we're still waiting for such a case to be brought, but it was acknowledged, and I think the AGs will continue to encourage the FTC to consider using its Section 5 authority. But Nicole, perhaps we could ask you to offer a few comments about that as well.
Sure, I'd love to. And I'm offering these comments in the context of trade and trade negotiations, both trade agreements that are being negotiated now and bilateral discussions that the U.S. government has routinely with its trading partners. And I can tell you that there's great interest in this issue. It is regularly on the menu with many of our trading partners that tend to not play by the rules in this area. So, you know, it's something that in many aspects of the federal government, many of the agencies, including the Commerce Department, something that's tracked, something that is regularly on the menu. And as we look at the negotiations of, let's say, for instance, the Trans-Pacific Partnership Agreement, IPR protection is very prominent. And hopefully, if that can come to some conclusion, a large representation of the GDP in the world will be bound by the protections, the IPR protections that are being negotiated under that agreement.
Good. Other questions from folks online?
Again, that's star one to ask a question. Star one. If there are no further questions at this time.
Okay, thank you, operator. I would like to announce that the video of this panel will be available via a link that will be sent out to all of you who have registered for this panel. It will allow you to download the video via Dropbox. So watch for that if you'd like to be able to review this video afterward. Any further questions, folks here in the room? Okay, seeing none, I'd like to conclude by once again thanking the ABA for putting this panel together, led by the State Enforcement Committee Chair, Vic Doman, and his Vice Chair, Greg McCurdy. Our thanks to NAM for hosting us here today and for being a co-founder of NAJI. And thanks to our outstanding panelists, all five of them, Attorney General Cooper, Chief Deputy Bates on behalf of Attorney General Pruitt. We'd like to thank Stacy W., whose name I'm now pronouncing a little bit better than before. My Cajun accent was a little off before, Stacy. Thank you very much in all sincerity. Thanks to General Caldwell. Much appreciated. Travis, thank you very, very much, and we really appreciate your continuing participation on these issues. And Nicole, again, thank you, and thanks for being part of the NAJI board and serving as our vice chair. We really appreciate it. With that, we'll conclude, and thank you all once again.